Hello, ladies and gentlemen. My name is Isaac Christopher Lubogo. Today we want to talk about international law, and I'm going to give you an introduction of what international law would basically consist of, and what we need to comprehend as far as international law is concerned. For starters, international law basically is a comprehensive system of rules and principles that govern the relationship between states and other international actors in the global community. And basically it plays a vital role in terms of maintaining what they call international order, promoting cooperation, and even facilitating the peaceful resolution of conflicts in the world, in the bigger world. Of course, you're going to ask me perhaps why we have challenges in terms of disputes, international disputes between different countries. So basically the body of law is a reflection of the shared interests and values of the international community in terms of encompassing a wide range of subjects, from the rights and responsibilities of states to the protection of human rights and the regulation of trade and even the preservation of the environment. And sometimes international law is characterized by several key principles and concepts that I would like us to go through. At a later stage, I will give you some case law to support these principles and concepts. Concept number one, or principle number one, will be what they call the consent of states. So one of the fundamental principles of international law is that it is based on the consent of states. In other words, states voluntarily enter into agreements and treaties binding themselves to specific obligations and rights, and this underscores the sovereign equality of states and the ability to engage in what they call international relations freely. Yeah. Concept number two, or principle number two, would be what they call state sovereignty. Sovereignty basically is a core concept in international law. It emphasizes a state's exclusive authority over its territory and the conduct of its foreign affairs. So states are expected to respect the sovereignty of others and avoid interfering in their international affairs. We will see how this has played out. Principle number three is what we call sources of international law. And under it, we are comprehending that international law basically derives from multiple sources, including treaties, customary international law in terms of practices and beliefs as accepted law, general principles of law recognized by civilized nations, and also what we call legal scholarship. We will comprehend some of those things at a later stage. And then principle number four is what we call international organization. Under international organizations such as the United Nations, perhaps also International Criminal Court, and region bodies that have actually emerged as key actors in international law. So they play roles in conflict resolution in terms of the promotion of human rights and the development of what they call international standards, and that is important. And concept number five would encompass things like dispute resolution and international law. So international law basically provides for mechanisms for peaceful settlements of disputes, including International Court of Justice, what they call the ICJ, and in terms of arbitration and also mediation. We may comprehend if we have enough time to go through some of that. And then we want to also talk about what they call evolution and adaptation. International law is not static, so it evolves and adapts to new changes and circumstances. So this adaptability is essential to address what they call contemporary issues, such as those related to cybersecurity, for example, climate change, and even human rights. So that's also something that is extremely important for us to comprehend. Now, listen. International law basically serves as a framework, as I said, for the global community to maintain order and stability, to protect human rights and address pressing international challenges, and basically it influences the behavior of states and also shapes the interaction between countries, in other words, helping them to prevent conflict and promote cooperation in a complex and interconnected world, such as international diplomacy or even governance. I know that I've mentioned and I've made some YouTube on the war between Ukraine and Russia, and I've also made something in terms of Israel and Palestine and how international should be played out. Anyway, the core principles of international law are fundamental concepts that underpin the international legal system and guide the conduct of states and international actors. So each principle basically is supported by specific legal instruments. So in many cases, in terms of case law, it will help us to define and enforce these principles. Additionally, these principles serve as various purposes in terms of maintaining peace, security, in terms of protecting human rights. And I'm going to give you some core principles in terms of international law, along with relevant legal instruments such as case law and their purposes, so that you can understand. I'm trying to place the contextualization of these principles in terms of how they're played out in terms of case law. In terms of principle that had to do with sovereign equality of states, the legal instrument would be the United Nations Charter, which is 1945, Article 2, Subarticle 1. But also in terms of case law, you want to look at the case of called Nebleton case, which is the Listen versus Guatemala, which is 1955, which was primarily about nationality that established the principle of sovereign equality. In terms of purpose, it was there to ensure that all states have equal standing in terms of rights, in terms of international relations, promoting peaceful coexistence and even interference in domestic affairs. Another principle or concept would be in terms of what they call prohibition of use of force. The legal instrument here that comes to mind is the United Nations Charter, again, 1945. If you look at Article 2, Subarticle 4, in terms of case law, you want to look at the Nicaragua case, Nicaragua versus United States, which is 1986. It addressed issues that related to the use of force, including the principle of non-intervention, okay? And in terms of purpose, it helps us to prevent war in terms of conflicts by prohibiting the threat or use of force in international relations, with exceptions of self-defense or Security Council authorization. Remember that. Now, another concept that you want to comprehend is in terms of what they call self-determination. Now, under that, for purposes of legal authority, you may, as a legal instrument, again, you may want to invoke United Nations Charter 1945 in terms of the preamble and the various resolutions. In terms of case law, while self-determination basically itself is more of a principle than a legally defined term, the Western Sahara case, 1975, is an example of a situation where self-determination issues were actually considered. And in terms of purpose, it was relevant in terms of recognizing the right of peoples in terms of determining their political status and pursuing of economic, social, and even cultural development, often invoked in the context of decolonization. Another concept that is important in terms of international law that has played out is what they call good faith and pacta sunt servanda in terms of agreement, meaning agreements must be kept. Good faith and pacta sunt servanda, agreements must be kept. As a legal instrument, you want to look at the Vienna Convention on the Law of Treaties, 1969. In terms of case law, while this is not tied to a specific case, the principle of good faith is fundamental as a concept in terms of international law and is the principle of pacta sunt servanda. In terms of purpose, it will ensure that states uphold their treaty obligations and act honestly and fairly in their international relations. Please remember that. Okay. You may also want to comprehend another aspect or principle or perhaps concept in terms of what they call customary international law. Now, under this, by virtue of a legal instrument, customary international law is based on states' practice and what they call opinio juris, a belief that practice is legally required. It does not rely on a specific treaty. In fact, in terms of case law, you might look at the North Sea continental shelf cases in terms of Germany and Denmark, and then Germany and Netherlands, and that is as far as 1969. And it confirmed the significance of state practice in customary international law. In terms of purpose, you want to argue and say that it helps us provide for what they call a source of international law reflecting practices accepted as legally required by the states. That's another important aspect that you may want to comprehend. Now, listen, another aspect that you may want to argue is the concept of human rights. When talking about international law, you cannot neglect human rights. In terms of legal instrument, the Universal Declaration of Human Rights, which is 1948, and numerous human rights conventions, for example, the International Covenant on Civil and Political Rights. In terms of case law, various international and regional courts such as the European Court of Human Rights have delivered judgments defining and even enforcing these human rights. And that becomes a question of importance. It helps us in terms of protecting and promoting the inherent dignity and equal rights of all individuals, ensuring that states respect and uphold human rights. That is super important. Okay. Another concept that you may want to argue still when you're dealing with international law is what they call state responsibility. In terms of legal instrument, you may want to invoke articles on state responsibility in terms of International Law Commission of 2001. In terms of case law, you may want to look at the case of Trail Smelter Arbitration, which is USA versus Canada, which happened in 1941, which addressed the issue of state responsibility for transboundary pollution. In terms of purpose, it helps us to determine when and how states are held accountable for internationally wrong acts and even their consequences. So that's again something that is important for us to comprehend. Then we may also want to argue in terms of what they call the principle of non-intervention. By way of a legal instrument, you may want to invoke again the United Nations Charter of 1945, specifically look at Article 2, Subarticle 7. In terms of case law, you may want to invoke the Nicaragua case, Nicaragua versus United States, 1989, which basically clarified the principle of non-intervention. Yeah, and then in terms of purpose, it helps us to prevent interference by one state in internal affairs of another state, respecting its state sovereignty. Now, obviously, every principle that I'm trying to invoke or talk about here has actually been abused in one way or the other, and we may have some examples that we may discuss later. But then another principle that is important is the principle of jus cogens. Jus cogens as a legal instrument, while not associated with a single treaty, jus cogens norms are peremptory norms of international law, such as the prohibition of genocide, torture, and even slavery. In terms of case law, various international courts and tribunals, including the Nuremberg trials and the Rome Statute of International Criminal Court, have made serious references in terms of what they call jus cogens norms. Okay, so in terms of purpose, it helps us to establish fundamental norms from which no derogation is actually permitted, and to protect fundamental human rights and the international legal order. So again, that becomes very, very important in terms of international law. Another aspect that we need to comprehend when you're talking about international law is the principle of comity. Now, by virtue of legal instrument, this is not tied to a specific treaty, but is a general principle of international law. Okay, now in terms of case law, comity is a concept rooted in international courtesy and reciprocity, but not typically associated with specific case law. In terms of purpose, it helps us to promote cooperation and goodwill among states by recognizing and respecting each other's laws and jurisdiction. That becomes extremely important for us to comprehend as well. Okay. In terms of other concepts, you may also want to argue in terms of what they call the principle of state immunity. Yeah, as a legal instrument, you may want to invoke the United Nations Convention on Jurisdictional Immunities of States and Their Property, which is 2004. In terms of case law, we could argue and say that various cases and international conventions that deal with the issue of state immunity, including those that have to do with jurisdictional immunities of the state. You want to invoke the case of Germany versus Italy, 2012 case. In terms of purpose, it will help us to grant states immunity from the jurisdiction of foreign courts in certain cases, preserving what they call diplomatic relations. Yes? Okay. In terms of another component that we may want to argue in terms of international law is the principle of proportionality in armed conflict. As a legal instrument, you may want to look at international humanitarian law, including the Geneva Conventions of 1949 and their additional protocols. Yeah, in terms of case law, cases before international and hybrid courts such as International Criminal Tribunal and the former Yugoslavia, what they call the ICTY, have dealt with the principle of proportionality. In terms of purpose, it helps us to limit the use of force in armed conflicts and ensure that the harm caused is not excessive in relation to the military advantage gained. One wonders whether or not the issues that are happening right now in Palestine in terms of the attack by Israel have actually not exceeded in one or the other. But those are arguments that we may want to look at the end. We also want to argue in terms of the principle of orga omnes, in terms of obligations to the international community as a whole, In terms of legal instrument, this principle is a general concept in terms of international law. So in terms of purpose, it establishes that certain obligations are owed by states to the international community as a whole and are to be protected by all states collectively. For example, the prohibition of genocide under the Genocide Convention is an erga omnes obligation. The spelling is ERGAOMNES, obligation. Remember that. And then also another principle is what they call the principle of territorial integrity. By virtue of legal instrument, while not tied to a specific treaty, the principle of territorial integrity is a fundamental concept in international law, and it emphasizes the importance of respecting the sovereignty and territorial integrity of states, aiming to prevent the use of force to change borders. That's another super important aspect that you may also want to comprehend. Then you may also want to look at the principle of pacta tati. Pacta tati. In terms of spelling, it would be PACTA-TERTII. In terms of rights and obligations of third parties. By virtue of legal instrument, this principle is a general concept in international law, and it helps to address the rights and obligations of third parties not originally party to an agreement. So it can have implications in cases, for example, where the treaty impacts on rights and interests of non-parties. Please remember that. Now, you could also argue another principle that is important in international law is the principle of reciprocity, right? In terms of that, as a principle, this is a general concept in international law, and it underscores the mutual exchange of benefits and obligations between states in international relations. So it promotes fairness and balance in states' interactions. So remember that. That's another important aspect I need to comprehend as well. We could also argue another principle in terms of international law, which is the principle of aut deterre, aut judicare. In other words, extradite or prosecute. Aut deterre, aut judicare. Spelling AUTDEDERE, AUT judicare. Extradite or prosecute. The principle is enshrined in various treaties, including the Convention Against Torture and other cruel, inhuman, or degrading treatment or punishment, which was happened in 1984. In terms of purpose, this principle obliges states to either extradite individuals accused of serious crimes or prosecute them domestically, thereby preventing impunity of such crimes. And all these are super important international obligations. We could also argue the principle of freedom of the high seas. In terms of legal instrument, customary international law, and the United Nations Convention on the Sea of the Sea, that is of the law of the sea, that is 1982. In terms of purpose, this principle basically allows for freedom of negotiation or navigation in terms of high seas and regulates activities in international waters to prevent conflicts and promote peaceful use. Remember that as well. Now, another important principle is also the principle of sustainable development. By virtue of legal instrument, you want to argue and say that the principle is basically enshrined in various international agreements, including United Nations Conference on Environment and Development, which is UNCED, or Earth Summit, which happened in 1992. This principle basically emphasizes the need to balance economic, social, and environmental considerations in decision making to ensure the well-being of current and future generations. Remember that as well. You could also argue in terms of international law the principle of state non-recognition of unlawful situations. By virtue of legal instrument, this principle is part of customary international law. And in terms of purpose, it guides states not to recognize or provide assistance to situations arising from serious breach of international law, such as an illegal occupation or annexation. You will ask me certain questions of Crimea and the likes, but those are questions that again we will discuss, and we have already discussed, by the way, some of our different YouTubes when we talk about different conflicts. For example, the Russia-Ukraine conflict as well, because we also handle the Crimea issue. Then the principle of prohibition of aggression. In terms of legality, the principle is established under the United Nations Charter of 1945, specifically Article 2, Subarticle 4. And basically it prohibits the use of force in international relations and is the cornerstone of the collective security system established by the UN Charter. Remember that. And then you could argue also in terms of the principle of obligatory dispute settlement. Yeah? By virtue of legal instrument, the principle basically is embedded in international treaties such as the Vienna Convention on the Law of Treaties, that is in 1969, specifically Article 33. In terms of purpose, it obligates states, for example, to seek peaceful dispute resolution mechanism before resorting to the use of force. Now, incredibly, in spite of the fact that we have all these things written down, we still have challenges in the world today, and one wonders whether or not these laws are in place or not. But again, it is my mandate to explain to you some of these, and then we shall see how, where, and when, or where they have failed to be applied. We could also argue in terms of the principle of no impairment of fundamental interests. By virtue of legal instrument, the principle is a general concept in international law, and it underscores that states should actually avoid actions that could impair the fundamental interests of other states, aiming to prevent conflicts and maintain good relations. When you listen to all these principles, one wonders why we're having problems today in terms of the different challenges. Talk about Uganda, Congo, talk about Rwanda, Uganda, talk about Russia, Ukraine, talk about Israel, Palestine, name it. We also have another principle, the principle of ega omnes partes, obligation to other parties. The principle is associated with various international agreements, particularly in the context of human rights convention. Yeah, it highlights that certain obligations under treaties are owed not only to the international community as a whole, but also to specific states or parties. Interesting, wonderful arguments here. It's interesting, as I said, to know that almost everything that we're going to talk about here has either been used well or misused. And the onus is on you to comprehend some of these aspects. The principle of international commissions and tribunals, for example. Various international agreements and conventions have actually established international commissions and even tribunals, such as the International Court of Justice, the ICJ, and Permanent Court of Arbitration, the PCA. In terms of purpose, these institutions facilitate the peaceful settlement of international disputes and promote the rule of law in international relations. Yeah, so you could argue them again in that context. Then we could also argue in terms of what they call the principle of non-discrimination. Yeah, in terms of legal instrument, non-discrimination basically is a fundamental principle in numerous human rights treaties, such as International Convention on the elimination of all forms of racial discrimination. Okay, what they call the ICERD, yeah, which happened in 1966, and the Convention on the elimination of all forms of discrimination against women, but they call the CEDAW, which was in 1979. In terms of purpose, this principle basically requires that individuals and groups are actually treated equally without discrimination based on race, gender, or other protected characteristics, ensuring equal protection and opportunities. So when you see all these things international, in terms of these international rights and obligations, one wonders why the world is still finds itself in a quagmire in terms of all the breaches that ordinarily would have been cured by the international obligations or laws that I'm mentioning. Talk about the principle of state responsibility for transboundary harm, for example. The International Law Commission articles on the responsibility of states for international wrongful acts, that was in 2001, basically establishes that states are actually responsible for harm caused to other states due to international wrongful acts, and setting rules for reparation and dispute resolutions as well. So all these aspects become interesting in terms of arguing it from an international context. So international law is a very, very interesting subject, because when you read it, you say, man, I think we're in a perfect world if only we can oblige by these principles. Not so. Talk about the principle of neutrality. Neutrality is a customary principle in international law and is found in various treaties. Yeah, so neutrality basically obligates states not to take sides in armed conflicts and aims to protect the rights and interests of neutral states during times of war, for example. I mean, you can mention the wars that are happening right now in the world in 2000 and what? And 13, and then you can argue and then see whether or not these obligations or these mandates wouldn't occur on them as well. Talk about the principle of immunity of international organizations, for example. Yeah, various international agreements and practices, including the Convention on the Privileges and Immunities of the United Nations, for example, way back in 1949. In terms of this principle basically grants immunity to international organizations, protecting them from legal actions and even ensuring that their independence and effectiveness in terms of functionality is not, is not breached at all. So, but the question is, do we see breaches in terms of this component? Talk about the principle of consensual nature of treaties, for example. In terms of this principle, basically, of treaty consent is a fundamental concept in international law and is enshrined in the so-called Vienna Convention on the Law of Treaties, which was signed way back in 1969. Yeah, and the argument here was to emphasize that states enter into treaties voluntarily and through mutual consent, ensuring the treaty obligations are freely undertaken. Yeah, and these are questions that, again, in the world that we're living in today, as of now, 2013, one wonders whether or not these are really playing their part in effecting or guaranteeing a stable world. Talk about the principle of non-refoulement. Yeah, non-refoulement is a fundamental principle under human rights and refugee law instruments, including the 1951 Refugee Convention and its protocol in 1967. Yeah, and the purpose was basically non-refoulement prohibits states from returning individuals to a country where they may face prostitution, torture, or other serious harm. So I'm just opening our minds into understanding the different international conventions and laws that ordinarily would protect us. What a wonderful world if only these things were put in action. Not so. Talk about the principle of state sovereignty over natural resources, for example. Yeah, this principle basically is based on customary international law and is also affirmed in international agreements on environmental conservation and sustainable development. Yeah, it underscores that a state's right to control and manage its natural resources within the framework of international law while promoting responsible, resourceful management. Yeah, and these are arguments that I'm talking about in terms of the breaches and how we see countries that have gone ahead to get stuff from other countries without their mandate at all. Talk about the principle of free navigation and overflight. This principle basically is enshrined in the United Nations Convention of the Law of the Sea, which is UNCLOS 1982 law. Remember? And the purpose basically is to ensure the freedom of navigation and overflight on the high seas, in territorial waters, and in exclusive economic zones, fostering what they call international maritime commerce, for example. These are issues that you need to comprehend. I'll emphasize again the principle of erga omnes in terms of obligations. The principle is implicit in various international agreements and has actually been recognized by international courts and tribunals. So, erga omnes obligations are obligations to the international community as a whole, serving to protect what they call fundamental rights and values. So one wonders whether or not these are actually being seen, being experienced, and being enjoyed in the world that we live in today. Talk about the principle of good neighborliness. Yeah, in terms of the principle, this basically is based on what they call customary international law, and it encourages states to maintain friendly and cooperative relations with other neighbors, promoting stability and peace in religions, okay, or regions perhaps. Now the question is whether or not these are really still being seen in the world that we live in today. Talk about the principle of respect for human dignity. Yeah, the respect for human dignity becomes a fundamental concept in various human rights, okay, and as an instrument, including the Universal Declaration of Human Rights, which happened way back in 1948. Yeah, in terms of purpose, it underlines the inherent worth and value of every individual. So guiding states in terms of protecting and upholding what they call human rights. These are important aspects that we need to comprehend. Yeah, talk about the principle of non-use of nuclear weapons, for example. Yeah, in terms as a legal instrument, the principle basically is supported by various treaties, including the Treaty on the Non-Proliferation of Nuclear Weapons, what they call the NPT, which happened way back in 1968. And the principle reinforces the commitment to prevent the use of nuclear weapons, promoting disarmament and non-proliferation. So that's another aspect that you need to comprehend. Whether or not we've seen an abuse in that's a question of debate. Talk about the principle of customary international environmental law as a principle. Yeah, in terms of customary international environmental law, it's basically based on the state practice and opinion jurists regarding environmental protection. Yeah, and it addresses environmental challenges and emphasizes the importance of states taking measures to protect the environment and biodiversity. So, my friends, international law, I could go on and on, but the importance of it is to shed light on the importance of international law and why we need to take it as a very serious subject, even those of you who are studying it at law school or other, disciplines for that sake. You may also want to argue the principle of respect for the rights of indigenous people, for example. The principle is reflected in United Nations Declaration on the Rights of Indigenous People, yeah, which happened way back in 2007. And it recognizes the rights of indigenous people in terms of self-determination, cultural preservation, and the protection of lands and even resources, which reminds me of the book that I wrote in terms of protecting indigenous languages. Find it at lubogo.org or suigeneris.com. Then you could also argue the principle of obligation to prosecute international crimes. Yeah, and basically this principle is supported by various international treaties and customary law, such as the Rome Statute on International Criminal Court, the ICC, which happened way back in 1998. And basically this principle obligates states to investigate and even prosecute individuals responsible for serious international crimes in terms of ensuring accountability, justice, and the like. So these are things that, ladies and gentlemen, we need to comprehend when we talk about the subject of international law. You could also talk about the principle of responsibility to protect, what they call the R2P, in terms of responsibility to protect. It becomes a concept established through various international reports and discussions rather than a specific treaty. Yeah, so the R2P underscores the international community's responsibility to protect populations from mass atrocities, including genocide, war crimes, ethnic cleansing, and crimes against humanity. I mean, how beautiful these are in writing, but the other question is, how effective are they in action? And that perhaps is the bigger question. Look at the principle of state accountability for violations of human rights. Yeah, in terms of this principle, for example, is supported by various human rights conventions, such as the International Covenant on Civil and Political Rights. Yeah, what they call the ICCPR, which happened way back in 1966. And its purpose was basically to hold states accountable for human rights violations committed within their territories and requires remedies for victims. Now, these are, again, super fundamental, nicely written, nicely carved words. The other question is, do we see these acting in the world that we live in today? The opportunity that you have today is to shed light on some of these principles and say, by the way, we have it. Then the question is, do we see its applicability today? How effective? What is the efficaciousness, if you have to argue? How about the principle of non-interference in domestic affairs? The principle is enshrined in the United Nations Charter, 1945. Look at Article 2, Subarticle 7. It aims to prevent external interference in domestic affairs of states, respecting their sovereignty and self-determination. Yeah? So these are issues that worry us in the world that we live in today. Talk about the principle of non-extraterritorial application of domestic laws. Yeah? This principle is supported by customary international law. Yeah? And it emphasizes that a state's domestic law generally do not apply extraterritorially, meaning they don't have jurisdiction beyond their own territory. Isn't that beautiful? Yeah, talk about the principle of permanent sovereignty over natural resources, for example. This principle is reflected in the United Nations General Assembly Resolution 1803, okay, which is also number 27 of 1962. And its purpose basically is to reaffirm a state's right to exercise permanent sovereignty over its natural resources, including the right to nationalize or regulate them for the benefit of its people. Yeah, incredible arguments here. You could also argue in terms of the principle of unlawful state of affairs as another important principle in international law. So while not tied to a specific treaty, the principle basically is recognized in customary international law. Yeah, and its purpose basically addresses situations, for example, where the state maintains unlawful condition, emphasizing the need for remedies and resolutions. Yes, so that is something again that you may want to comprehend when you're talking about international law. So my friends, the principles add, as I say, to the framework of international law and help us to provide guidance on matters such as human rights, such as state sovereignty, and the resolution of international disputes. So these basically help us to play crucial roles in promoting peace, justice, and cooperation at an international level. And that's why I am super emphasizing that you just cannot take, you just cannot ignore important aspects that have to do with international law. Yeah. Now, I may want to give some supporting supporting case laws in terms of these core principles, so that you could understand that these have been played out in certain jurisdictions, and these are not just stories or principles that have been limited in terms of books or regulations or mandates. I'll give an example. For example, sovereign equality of states. When you look at the case of Corfu Channel case, which is United Kingdom versus Albania, which happened in 1949, before the International Court of Justice, emphasized the principle of sovereign equality and non-interference in international affairs of states. Yeah. Another, in terms of a play out, in terms of prohibition for the use of force, for example, you could look at the case of Nicaragua. They call it the Nicaragua case, but look at Nicaragua versus United States, which happened in 1986. This was a significant case that dealt with the use of force and highlighted the prohibition on intervention in international affairs of another state. Yeah, I'm trying to break down the cases for you so that you can understand a principle and the case that played out. In terms of self-determination as another principle, look at the case of East Timor case, yeah, which is Portugal versus Australia, 1995. It examined issues related to self-determination and the right of peoples to determine their political status, yeah. And then in terms of the principle of good faith and Pacta Sant Servanda, in terms of case law, while not tied to a specific case, you could argue that these principles are fundamental in terms of treaty law and are actually reinforced by the jurisprudence of international courts and tribunals in cases involving treaty obligations. So again, that becomes another important aspect. Then if you are to argue in terms of customary international law is basically primarily based on the state practice and what they call opinio juris. So while they may not be specific cases, it's informed through what they call cumulative state practice, and they believe that that such practices are legally required, and that's super important for you to comprehend as well. Then in terms of another example, you may want to argue in terms of human rights, and this becomes a very big mandate because human rights is really big, but various international courts and tribunals, for example, such as the European Court of Human Rights and the, for example, American Court of Human Rights, have actually delivered judgments defining and even enforcing human rights principles, for example, as a question of debate. And then if you're to argue in terms of state responsibility, you could also look at it this way in terms of what they call the trail smelter arbitration. case, which is USA versus Canada, which happened in 1941, which addressed issues related to state responsibility for transboundary pollution, contributing to the development of that particular principle. Yeah, and then you may also want to argue as an example in terms of what they call the principle of non-intervention. I'm trying to give out case law for supporting those principles. In terms of case law, you may want to look at what they call the Tadic case, that is the prosecutor versus Tadic, which happened in 1995 before the International Criminal Tribunal of the former Yugoslavia, which is ICTY, which addressed issues of non-intervention, sovereignty, and the prohibition of the use of force. Yeah, and then you may also want to look at the principle of jus cogens. The pronunciation may be different, but it's spelled as JUS, jus cogens. So jus cogens norms have actually been affirmed in various cases, including the legality of the use of force. A good example is Serbia versus Montenegro, Serbia and Montenegro versus Belgium, which happened in 2004 before the International Court of Justice, where the court recognized the overriding principle of importance in terms of jus cogens norms. Yeah, and then if you have to argue in terms of the principle of comity, in terms of case law, while again not tied to a specific case, we could argue that the principle of comity is recognized in various international judgments and conventions as a guiding principle for state interactions, particularly in matters of legal cooperation. So again, that becomes a question of importance for us to comprehend as an example. Then in terms of an example, in terms of the principle of state immunity, you could argue in terms of the jurisdiction of immunities of the state. Particularly look at the case of Germany versus Italy in 2012 before the International Court of Justice that dealt with issues related to state immunity and provided important legal precedents as well. So I'm just trying to break it down for you and give you substantive cases that would support some of these international concepts or principles as we've just seen them. You may also want to look at the principle of proportionality in armed conflict. In terms of case law, you want to look at the case of Israel Lebanon case, advisory opinion 2004 before the International Court of Justice that addressed the principle of proportionality and the use of force in armed conflict. Perhaps another would be the ongoing conflict between Israel and Palestine as we know it today. Yeah, and then you could also argue in terms of the principle of non-use of nuclear weapons. Yeah, so again, while not tied to a specific case, the advisory opinion on the legality of the threat or use of nuclear weapons way back in 1996 by the International Court of Justice was a landmark in terms of addressing the prohibition of the use of nuclear weapons. But one wonders now, of course, you could argue it in terms of specifically weapons as opposed to energy, where you could argue that nuclear energy can actually be used for useful rather than vengeful, rather than dangerous approaches. You could also argue in terms of the principle of responsibility to protect, which is R2P. The responsibility to protect in terms of R2P is a concept rather than a specific legal principle, and was endorsed by the United Nations World Summit in 2005, and has since actually informed discussions on international interventions to protect populations from mass atrocities as well. Then you could also argue in terms of the principle of state sovereignty over natural resources. Remember, I mentioned that, but I'm trying to give you how these have been played out in terms of the world that we live in today. Yeah. In terms of a play out, you could look at what they call Texaco Chevron case, which is Anguda versus Texaco, which is 2003, involving environmental damage in the Amazon rainforest, for example. It raised questions related to the state sovereignty over natural resources and the responsibility of corporations in resource extraction. Yeah. Then you may also want to argue in terms of the principle of free navigation and overflight. In terms of case law or case play out, you want to look at the issue of South China Sea arbitration, that is Philippines versus China, which is 2016, which addressed issues related to international and application of the United Nations Convention of the Law of the Sea, which is UNCLOS, emphasizing the principle of freedom of navigation and overflight. Yeah. Then again, in terms of a play out, in terms of the principle of erga omnes, in terms of obligation, we could look at the case of Barcelona traction case, which is the second phase, which is Belgium versus Spain, 1970. So before the International Court of Justice recognized obligations of egar omnes in terms of owed to the international community as a whole. So the principle is important for the protection of fundamental rights and values as well. Again, in terms of another play out, in terms of the principle of non-discrimination, you want to look at the case of Southwest Africa in terms of Ethiopia versus South Africa. Then you could also look at Liberia versus South Africa way back in 1966. So before the International Court of Justice that addressed issues of racial discrimination and non-discrimination as well. Yes, another play out on another principle, the principle of state accountability for violations of human rights, for example. You may want to argue and look at that in terms of various cases before international and regional human rights courts, such as the Inter-American Court of Human Rights and the African Court on Human and People's Rights, which have actually ruled on state accountability for human rights violations, supporting that particular principle as I've just mentioned. So my friends, it's interesting to note, as I said, that we have these played out, we have these tested, and I could go on. Another that comes to our mind is the principle of non-extraterritorial application of domestic laws. How has it played out? The legal consequences of the construction, for example, of a wall in the occupied Palestinian territory. Advisory opinion 2004 by the International Court of Justice highlighted issues related to extraterritorial application of domestic laws. And then you could also argue there's another principle in terms of the principle of respect for the rights of indigenous people. You could argue in terms of what they call the Awas Tingini case, which is Mayagana Sumo, Awas Tingini community versus Nicaragua, which happened in 2001 before the International American Court of Human Rights, which emphasized the protection of indigenous land rights and the duty of states to respect these particular rights. You could also talk about the principle of state responsibility for transboundary harm as another play out. In terms of a play out, please look at the case of Trail Smelter Arbitration, which is USA versus Canada way back in 1941, where a set of significant precedent for state responsibility regarding transboundary pollution and environmental harm. And then another play out is in terms of what they call the principle of neutrality. Here, well, again, not tied to any specific case, the principle of neutrality has actually been applied in various international conflicts, including the recognition of Switzerland's neutrality during both world wars. Interesting argument. One wonders whether we have any neutral country today. We are arguing that Africa is playing a neutral role when it comes to the conflict between Russia and Ukraine, but that is a question of debate. But you could also argue in terms of the principle of immunity in terms of international organization. So basically what we need to comprehend is that cases before the national courts and tribunals have actually dealt with the immunity of international organizations such as the Bahami and the Selamati case of 2007 before the European Court of Human Rights. And then another example that plays out is in terms of the principle of freedom of the high seas. You might look at the case of SS Lotus case, that is France versus Turkey in 1927, before the Permanent Court of International Justice as a significant case involving the issues of high seas and the freedom of navigation. Okay? You may also want to look at another principle as a play out in terms of the principle of permanent sovereignty over natural resources. And the case, or the one that comes to mind, is the uranium mining case, that is Niger versus France, which is 1975, before the International Court of Justice that addressed the issues of sovereignty over natural resources. So again, interesting to note that almost every principle that I've talked about has been played out, and I'm laboring to give you these examples of how they've been played out. Look at the principle of unlawful state of affairs. While again not tied to a specific case, the principle of unlawful state of affairs is often invoked in international disputes, including cases related to international disputes and unlawful occupations. And then another playout would be in terms of the principle of non-interference in domestic affairs. We could note that the principle of non-interference is relevant in various cases related to state sovereignty and non-interference in international affairs of states, such as cases before the International Court of Justice. Yeah, and that's something that again comes of interest to us. Then you may also want to look at the principle of non-extraterritorial application of domestic laws as a playout. As a playout, you may want to look at the case of the United States in terms of the measures that are affecting the cross-border supply of gambling and betting services, what they call the DS-285 of 2005. The case before the World Trade Organization that addressed issues that related to extraterritorial application of domestic laws. Yeah, so that's something that you may want to comprehend. And then another principle by way of playout is the principle of Ogna Omnes Pats. Ogna Omnes Pats. The spelling is ERGAOMNESPATES. In terms of playout, the genocide conversion case of Bosnia and Herzegovina versus Serbia and Montenegro in 2007. So before the International Court of Justice that examined the issues of state responsibility and the principle of Ogna Omnes Pats, or parties for that purpose. Okay, now you may also want to look at the principle of respect for human dignity. Yeah, and the cases before the international and regional human rights courts, such as the European Court of Human Rights and the African Commission on Human Rights and People's Rights, have dealt with issues of human dignity and the respect for human rights. So that's again a little bit self-explanatory. Now, you may also want to look at another principle as a playout, the principle of non-use of nuclear weapons. The one that comes to mind is the Marshall Islands nuclear disarmament cases of 2016 that brought by the Marshall Islands against nuclear armed states such as the United States, United Kingdom, and others, and raised issues related to nuclear disarmament and the non-use of nuclear weapons. Yeah, and then you also want to argue in terms of the principle of responsibility to protect, which is R2P, in terms of a playout. While R2P is not directly associated with any particular case law, it has actually informed international responses in terms of international crises, such as United Nations Security Council resolutions regarding the protection of civilians in conflict zones, including what they call the UNSCR of 1973 on Libya that happened in 2011. Yeah, and then I would probably want to also talk about a little bit in terms of the principle of state sovereignty over natural resources. I know I gave some case, but in question in terms of a playout, I could argue and say that the case concerning what they call Glab-Klikov, or what they call Glab-Klikov-Namayeros project in terms of Slovenia and Hungary, which happened in 1997, before the International Court of Justice that addressed issues related to sovereignty of states over shared natural resources. Yeah, you may want to do a little bit more of to impress yourself more on that. But also the principle of free navigation and overflight. You please remember the case of the United States versus the William, that is 1872. That this case is historical as an example because it involved the issues of freedom of navigation on the high seas. Yeah, and then I remember I mentioned some aspects in terms of the principle of Ogna Omnes as an obligation, the legal consequence of which had to do with the construction of a wall in the occupied Palestinian territory. Look at the advisory opinion of 2004 by the International Court of Justice that examined the Ogna Omnes obligations concerning issues of in the occupied Palestinian territory. I mean, in spite of the fact that we have these, as I said, we still have challenges that the world is facing today. And perhaps those are the bigger questions we could ask ourselves, that if we have this big brother called international law, why is it that we still have unanswered questions of Ukraine, Russia, of North Korea, America, of issues to do with Palestine, Israel, even in our countries? We have, how many times have we had issues in terms of Uganda, Rwanda perhaps, or perhaps Uganda, Congo, you know, Somalia, name those conflicts, Sudan, Southern Sudan, Northern Sudan, all those aspects. So these questions, again, in terms of international law, is where we need to learn to invoke international law and place it into context, so that international law cannot only be something that we feel in our books per se, but it's something that we can be able to apply in terms of you know, serving a purpose of creating a stable world. Okay, I mean, if you argue, for example, in terms of the principle of neutrality, the argument that the principle of neutrality is invoked on various international conflicts where states take to maintain a neutral stance during armed conflict is a question that someone can argue and say is a fallacy, for example. Yeah, I mean, do we see any neutral country really? How about the principle of immunity on international organizations, for example? How many times do we see instances where these international organizations have actually been attacked left, right, and center? In terms of the case play out, when you look at the Berhami and Saramanti case of 2007, before the European Court of Human Rights, that dealt with issues of immunity of international organizations operating in conflict zones, how many times have we seen bombs and you know, ammunition shredded against international organizations, including the Red Cross and the likes? Yeah. How about freedom in terms of playing out of freedom on the high seas? I just mentioned the Lotus case, France versus Turkey, 1927, before the Permanent Court of International Justice, that emphasized the principle of freedom of navigation, overflight on high seas. How about where people are in countries, superpowers, engage no-fly zones, even in areas where they really have no substantive jurisdiction per se? Yeah. How about aspects in terms of the principle of permanent sovereignty over natural resources? Yeah. We could argue in terms of Niger versus France, the disputes that we're having today, cases of countries that have now disbanded themselves from their colonial masters. Because, for example, in uranium mining, Niger versus France, before the National Court of Justice that examined issues that relate to sovereignty over natural resources, how many times do you see countries that have, you know, muzzled or even asserted themselves on minerals or things that belong to other countries? How about principles in terms of unlawful state of affairs, armed conflicts on territories? For example, look at the territory of the Congo case, the Democratic Republic of Congo versus Uganda in 2005, before the International Court of Justice, that addressed unlawful state activities in terms of territorial sovereignty and even responsibility, where countries like Uganda, under the mandate that they were pursuing, certain rebels entered their territory and extorted lots of stuff, and they were punished. Yeah, how about the principle of non-interference in terms of domestic affairs? How many times do we see cases that are played out, various cases related to the issues of sovereignty, non-interference, and in terms of self-determination, that have actually been brought before international courts and even tribunals, that illustrate the importance in terms of this principle of international law? How many times do we see other countries interfering in affairs of others, including sponsored CIA moves, or even mafia groups that have been bought to go and execute certain missions? How about the principle of non-extraterritorial application of domestic laws in terms of alleged violations? For example, in 1995, talk about the Treaty of Amity, where economic relations and consular rights, talk about Iran versus the United States in 2019, before the International Court of Justice, that involved disputes that led to extraterritorial application of domestic laws and even sanctions. Yeah, I mean, we could go on and argue and argue. One that really, although not specifically tied to a specific law per se, but is a principle in international law, is the Orga Omnes Parties that I just mentioned out. As I say, the principle where we are arguing that parties have actually affirmed in various judgments and legal opinions, shaping responsibility of states to protect certain fundamental rights and values of the international community as a whole. Yeah, but do we see this being played out today in terms of international law? And that's the question that I'm begging now, because now we now, other than setting the law, we're now going to the debate of trying to evaluate the efficaciousness of these things. The principle of, for example, of respecting human dignity. Cases related to human rights violations before international and even regional human rights bodies, I mean, have been so much and have played out. We have seen abuses to the extreme, you know, where we see people's rights being taken, thrown out in ventilators, and taken for granted. The principle of the non-use of nuclear weapons, as I say, although significantly we could argue that some of them were perpetrated to make attacks on countries like Iraq under the disguise that they had nuclear weapons, but we still haven't revisited cases that had to do with Nagasaki and Hiroshima, and then the arguments of nuclear emissions and the use of now super weaponry other than nuclear weapons per se. How about the principle of responsibility to protect? Again, the aspect that the concept of humanitarian intervention in terms of the responsibility to protect population has actually influenced international decisions and debates in cases of mass atrocities, for example. I mean, we could also argue in terms of the failure for the principle of state sovereignty over natural resources. I mean, that to me is the biting one. You could argue it in terms of the so-called Rhine arbitration, Belgium versus Netherlands in 2005, before the Permanent Court of Arbitration that addressed issues of state sovereignty over natural resources and environmental conservation. Now we see that happening in Africa, most especially, perhaps because Africa may not have the military muscle or the economic strength, but the exploitation is so terrible. The principle of free navigation overflight again. The case that plays out is the Panama case, Colombia versus Panama, 2012, before the International Tribunal for the Law of the Sea, that emphasized the principle of free navigation and overflight in relation to rights and obligations of coastal and even flag states, for example. So listen, even as we argue in terms of international law, it's one thing for us, as I say, to have the laws in our laws or in our books, or to be able to tell them, but the argument that I'm proponing here is that let's make a substantive reflection of the applicability of the laws in terms of the principles and how they are played out today in terms of guaranteeing a safer world. To me, that would make a much better case. And then the argument that even as we have these laws should not be played out to the detriment of other bodies. You would argue in terms of the ICC, for example, you can argue that over 7 African leaders have actually been taken. But how many European or American leaders have been taken and tried? And how effective have been those rights in terms of substantive justice anyway? Although you could argue that these African leaders were taken there by fellow Africans. But one would argue and say that it's because that they have been propelled to do so by these individuals who are pulling strings behind behind the curtains, as it were. So international law, again, has a substantive, vital role that it plays in terms of creating a safer world today. And that should be the spirit under which international law should be comprehended. But as I said, the problem we have is that, do we have responsibility in terms of state responsibility? Look at the Danube Dam case, Hungary versus Slovenia, 1997, before the international justice, that involved issues of state responsibility for just basic things like environmental harm caused by the construction of a dam on an international river, for example. Do we have substantive effects in that? Can we even argue that those laws are applicable today? Yes, we've seen them played. Are they being played to the interest of particular bigger people, to the detriment of weaker countries, for example? So these are components in terms of a substantive international law that I would like us to argue even as we comprehend international law on a much bigger scale. International law goes, as I said, beyond basic principles of just comprehending and understanding the principles that will govern. I've labored to mention certain aspects. Talk about the aspect of immunity in terms of international organization, for example. Nauru versus Australia involved issues related to immunity of international organizations, such as the International Monetary Fund. One can argue whether things like IMF and World Bank today, when they refuse to give out funds to Uganda because Uganda has actually passed a law on anti-homosexuality, is that something that is related substantially to a freedom that has been infringed without substantive evidence that this law is actually biting unfairly, or is it something that are using to victimize a whole economy that is dependent on their donations per se? Is that fairness in terms of argument? Can we argue that international mandate is being played out right on a small country with which population which is living with less than $1 a day, and you're putting them at ransom and say we're not going to give you money because you put that, So again, aspects, these international laws should be played under the mandate of substantive understanding of the entire justice, to use that phrase, unreservedly. Yeah. So even as we argue international law, please look at it on a bigger concept. Look at it in terms of how it protects human rights, how it protects environment, how it protects or defends armed conflicts, how it secures resource management. That to us would be more comprehensive in terms of a debate that is comprehensive in terms of the argument that we're proponing today. Listen, I'm going to argue for us one of the major locus classicus cases that comprehensively perhaps would address the various issues in terms of international law. Yeah? I've mentioned quite many, but I just want us to argue one that would probably cover all. The Trail Smelter Arbitration between United States and Canada, which was actually resolved through arbitration in 1941. Now, this case is often cited as a classic example in environmental law, in terms of state responsibility and dispute resolution under international law. Please understand that, under international law, although specifically environmental, but under international law. Now, for a background, for those of us who want the background, the Trail Smelter case revolved around the Trail Smelter, a large smelting plant located in Trail, British Columbia, Canada. Yeah? And its impact on the environment and health on residents in both Canada and the United States. Now, the plant emitted significant amounts of sulfur dioxide, which caused environmental damage in the form of pollution and damage to forests, to crops, and soil in the neighboring areas of both countries. Yeah? Are we together? Now, listen. In terms of key issues and international principles, those are the ones that I want to bring out. Principle number one, as far as international law, in terms of environmental protection, the case highlighted early concerns about environmental harm and the responsibility of states for damage caused by their activities. And it was one of the earliest instances where environmental issues were actually addressed in international law. Remember that. Principle number two, in terms of state responsibility. The case addressed the principle of state responsibility for transboundary harm. Yeah? It established that a state is responsible for ensuring that activities within its territories do not cause harm to neighboring states, particularly in cases of environmental harm. Are we seeing that principle? Principle number three, in terms of arbitration and dispute resolution, which is super important, by the way, ADR. Yeah? So the Trail Smelter case was resolved through arbitration, illustrating the importance of peaceful dispute resolution mechanism in international law. Okay? So this set a precedent for using arbitration as a means of resolving disputes between states. Yeah? Another principle that you could look out for is what they call international cooperation as a principle. The case demonstrated for us the need for international cooperation in terms of addressing cross-border environmental issues, and it emphasized the importance of states working together to prevent environmental harm and seeking solutions through diplomacy. Yeah? Now, by way of resolution, in terms of what I've just been arguing, the arbitration tribunal found that the United States had a valid complaint against Canada due to its environmental damage caused by the Trail Smelter. Now, the parties agreed that Canada would pay compensation to the United States, and Canada took steps to reduce emissions from the smelting plant, contributing to environmental protection. Okay, now, please remember that the Trail Smelter case remains significant in international law because it laid the groundwork for addressing what they call transboundary environmental issues. state responsibility for environmental harm, and peaceful resolution of disputes between nations. And it has, as I said, it illustrates the evolving nature of international law, reflecting the changing priorities and concerns of the international community. Okay, now, again, for purposes of emphasis, I could argue another important case, another landmark case that discusses various core principles in international law is the case concerning what they call the Gab-Kipokov Nigromas project, which is Hungary versus Slovakia, which is 1997, which was brought before the International Court of Justice. Yeah, and the case is notable for addressing several essential aspects of international law. But before that, let me again lay down a little bit of a background for you. Now, the Gab-Kipokov Nigromas project was a large water management project initiated by Hungary and Czechoslovakia. Some people call it Czechoslovakia, later Slovakia, in late 1970s. The project aimed to harness the Danube River's hydropower potential and improve navigation. However, disagreements arose between the two states, leading to the termination of the project and subsequent legal proceedings. Yeah? Now, the key issues and international law principles that I would want us to appreciate were as follows. Number one, treaty law and the law of treaties. Yeah? So the case involved the interpretation and application of the 1977 treaty between Hungary and Czechoslovakia concerning the project. So this raised issues related to treaty obligations and the principle of Pacta Sunt Servanda. Remember that. Number two, sovereignty and territorial integrity. The case addressed matters of sovereignty in terms of territorial integrity, state sovereignty over shared water resources, reflecting the principle of permanent sovereignty over natural resources. Remember that. Another aspect is the aspect of state responsibility. The dispute involved allegations of environmental damage caused by project bringing into play the principle of state responsibility for transboundary harm. Remember that. Another component that is important is peaceful settlement of disputes. The case again demonstrates the importance of peaceful disputes resolution mechanisms in international law, and the parties had agreed to submit the dispute to the ICJ, emphasizing the role of international courts in resolving disputes. Another principle that is important again to pick out is the aspect of environmental protection. Environmental considerations again played a central role in this particular case because it helped us highlighting the growing importance of environmental protection and sustainable development in international law. Please remember that. Okay, now by way of resolution, in terms of the case, the ICJ's judgment, please remember this, addressed various aspects of disputes, including the interpretation of the 1977 treaty and the responsibilities of Hungary and Slovakia under international law. The court found both states responsible for certain breaches of international law, but did not award specific compensation. Now, this particular case, as I said, is important because it delved into multiple facets of international law, including treaty interpretation, state sovereignty, environmental protection, state responsibility, and peaceful settlements of disputes. So it serves as a notable reference point of understanding the complexities and nuances of international law when applied in real-world situations and disputes between what? Between nations. So again, I don't know how many times I'm going to super overemphasize the importance of international law. International legal instruments include treaties, conventions, agreements, and they are very fundamental components in international law. Now, these instruments serve, as I said, as building blocks of international legal frameworks, and they play a crucial role in addressing global challenges in terms of ensuring cooperation between states and regulating a wide range of international activities. So, please understand that I'm going to discuss, but I would like to give you some specific international legal instruments and their use. Okay? Because we're talking about international law generally. Let me begin with the one that you probably know, United Nations Charter, 1945. The UN Charter is a fundamental or foundational international legal instrument that established the United Nations, the preeminent international organization dedicated to maintaining international peace and security. And it outlines the principles of state sovereignty, collective security, peaceful dispute resolution. So the UN Charter's provisions have actually been used to authorize peacekeeping missions, impose sanctions, and even address various global issues. Remember that. Another one is the Universal Declaration of Human Rights of 1948. This document is a milestone in itself in the history of international human rights law. It sets out fundamental human rights and freedoms to be universally protected. So the Universal Declaration has actually served as a guide for the development of numerous international human rights treaties and conventions, forming the basis for promoting and protecting human rights worldwide, by the way. Okay. Another interesting one is what they call the Vienna Convention on the Law of Treaties, 1969. This convention basically codifies essential principles of treaty law, including the formation, interpretation, and termination of treaties. It provides a comprehensive framework for the negotiation, conclusion, and implementation of treaties, contributing to the stability and predictability of international relations. Okay? I'll give you another one. The Paris Agreement of 2016. This treaty basically adapted under the United Nations Framework Convention on Climate Change, what they call the UNFCCC, aims basically to combat climate change by limiting global warming to well below 2 degrees Celsius. So the Paris Agreement sets a framework for international cooperation in reducing greenhouse emissions, promoting climate adaptation, and supporting sustainable development. Please remember that. I'll give you another one that is important. It is the Convention on the Law of the Sea, which is UNCLOS of 1982. So UNCLOS basically governs the rights and responsibilities of states in the world's oceans. Yeah? So it establishes rules for maritime boundaries, navigation, resource management, and environmental protection. So the UNCLOS is crucial for regulating activities in the world's seas and oceans, including fishing, shipping, and seabed mining. Remember that. Another important instrument is the Geneva Convention of 1949 and additional protocols. Now, the Geneva Conventions provide for humanitarian protection for victims of armed conflicts, including civilians and combatants who are no longer taking part in hostilities. Yeah? So they establish standards for treatment of wounded and sick individuals and prisoners of war. So these instruments are indispensable in the field of international humanitarian law, which is another component that you need to comprehend. Another interesting one is what they call the Rome Statute of International Criminal Court, what they call the ICC of 1998. This treaty established International Criminal Court, the first permanent international court with jurisdictions to prosecute individuals for genocide, war crimes, crimes against humanity, and the crime of aggression. So the ICC plays a crucial role in holding individuals accountable for the most serious international crimes. we will have a dispensation of the validity in terms of how it has played out on another day. Yeah, but please understand the international legal instruments are just a section of the many treaties, different conventions and agreements that form the backbone of international law. As I say, they serve as a tool to address pressing global issues, facilitate cooperation between states, and uphold the principles of international law. So they continue in terms of their continued performance or use in terms of development or adaptation is crucial in terms of promoting peace, justice, and stability in our so-called world. Yeah. Another interesting one is what they call the World Trade Organization agreements. Yeah. WTO agreements. They serve as international body regulating global trade, for example, and the agreements, including the general agreements on tariffs, for example, and trade, what they call the GATT or the GATT, and the agreements on trade-related aspects of intellectual property rights, what they call TRIPS, provide the legal framework for international trade in terms of as well as tariff reductions and dispute resolutions. Okay, and of course intellectual property, as I just mentioned. And then another is what they call the Convention on Biological Diversity, the CBD of 1992. Now the CBD basically addresses the conservation of biological diversity, sustainable use of its components, and the equitable sharing of benefits derived from genetic resources. And therefore it plays a vital role in preserving what they call global biodiversity. Yeah? And then you could also look at, I think I talked about the Rome Statute of the International Criminal Court, the ICC, remember? Which was established as a permanent court to prosecute individuals in most of these so-called serious international crimes. But I said we shall make an evaluation or in terms of the efficacy or how effective it has been in terms of advocating for its mandate as enshrined in whatever law that brings it into occurrence. Yeah, but then you could also argue in terms of the Convention of Elimination of All Forms of Discrimination Against Women, which is CEDAW of 1979. So CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, was a landmark treaty that promotes gender equality and the elimination of discrimination against women, and has widely been adopted and even ratified by states to advance women's rights. Yeah. And then you could also argue in terms of the Hague Convention, what they call the Hague or Hague pronunciation, the Hague Convention on the civil aspects of international child abduction of 1980. This convention basically addresses international child abductees or abduction in terms of cases, yeah, and it basically provides for mechanisms for the return of abducted children to their country of habitual residence in terms of ensuring their protection and well-being as well. Then you could also talk about the International Convention for the Protection of All Persons from Enforced Disappearance of 2006. This treaty basically aims to prevent and combat enforced disappearances and even hold perpetrators accountable. And it basically provides legal tools for protecting individuals from this grave violation of human rights. Yeah, so that's another important aspect that you may want to look at. And then you may also want to look at the Comprehensive Nuclear Test Ban Treaty, what they call the CTBT. Although not yet in force, but the CTBT aims to prevent nuclear weapons testing and contribute to nuclear disarmament. Its verification as a system plays a vital role in monitoring and verifying the compliance with the treaty as well. And then you may also want to look at the convention on what they call cybercrime. That's the so-called the Budapest Convention of 2001. This treaty addresses crimes obviously committed via the internet and other computer systems, and it promotes international cooperation in investigation and prosecuting cybercrimes. Yeah, and you may also want to look at the so-called Montreal Protocol on substances that deplete the ozone layer, way back in 1987. This treaty basically aims to protect the ozone layer by regulating the production and consumption of substances that actually deplete it, such as CFs, what they call CFCs, what they call fluorocarbons, okay, fluorocarbons, CFCSs, and has actually been effective in reducing ozone depleting substances as well. Then you also want to look at the Refugee Convention of 1951 and its 1967 protocols. These legal instruments basically provide a framework for the protection of refugees in their rights, and they define who, for example, qualifies as a refugee and establishes the rights and obligations of these host countries as well. Then you may also want to look at the Chemical Weapons Convention, what they call CWC, of 1993. The CWC prohibits the production of and stockpiling and the use of chemical weapons and their precursors, and it enables the Organization for the Prohibition of Chemical Weapons, the OPCW, to oversee in terms of compliance. We saw that, I think, a little bit in terms of Iran, America saga in the times of Barack Obama, if you remember. And then the Rome Statute or for the Special Court for Sierra Leone, which is SCSL of 2002. The SCSL was established to prosecute individuals responsible for all crimes against humanity and other serious violations of international humanitarian law during the Sierra Leone civil war. And that becomes another aspect in terms of international law as well. You may also want to comprehend the International Convention for the Suppression of Acts of Nuclear Terrorism, 2005. And this treaty basically aims to prevent acts of nuclear terrorism that requires states to criminalize such acts and even cooperate in their prevention and actually prosecution as well. You may also want to look at the Outer Space Treaty of 1967. This treaty basically establishes the principles governing the use and exploration of outer space, and it prohibits the placement of nuclear weapons in space and promotes peaceful cooperation in space activities. That is something also that you may find of interest as another international legal instrument of sorts. I know I mentioned something about the Convention on the Rights of the Child, which is the CRC of 1989. The CRC is probably the most widely ratified international human rights treaty because it sets out the civil, political, and even economic, or social, and even cultural rights of children, and emphasizes the best interest of the child, as it were. Excuse me. And then you don't want to forget the African Charter on Human and People's Rights, what they call the Banjul Charter of 1981. And the treaty basically establishes the African Commission on Human and People's Rights and promotes human rights and fundamental freedoms in Africa, as it were. And that's substantively important for those of us who come from this particular part of the world. You may also want to look at what they call the Arms Trade Treaty, which is the ATT of 2014. The ATT basically regulates international trade in conventional arms, and including small arms and light weapons, and aims to prevent their diversion to illicit markets. So that's substantially important as well to comprehend. Then don't forget the Kyoto Protocol, of 1997. This treaty basically established legally binding emission reduction targets for developed countries to address climate change, and it was a precursor to the so-called Paris Agreement, as I just noted. And then you may also want to look at the Convention on Cluster Munitions of 2008. And this treaty basically bans the use of production and even transfer and what they call stockpiling of cluster munitions, which pose risks to civilians. And that's substantially also important by way of international law. Then you may also want to look at what they call the Antarctic Treaty. The Antarctic Treaty. This treaty basically sets aside what they call Antarctica as a scientific preserve and bans military activity on the continent, promoting international cooperation in scientific research. And that's another important aspect that you may want to look at as far as in some international conventions as well. Then again, please don't forget the International Convention on Elimination of All Forms of Racial Discrimination, which is ICERD of 1966, which addresses racial discrimination and promotes the elimination of all forms of racial segregation and apartheid. Substantively, you could argue in terms of whether or not we are seeing these things, whether or not they really serve the purpose that were brought into place in the first place. Then the Convention on the Prohibition of the Use, Stockpiling, Production, and Transfer of Anti-Personnel Missiles or Mines and their Destruction. Look at the Ottawa Convention of 1997. Basically, the treaty aims at eliminating anti-personnel landmines and addresses their humanitarian impact as well. Then you may also want to comprehend the Vienna Convention on the protection of the ozone layer. I think I talked about 1985, and Montreal Protocol on substances that deplete the ozone layer. Please remember that these work together in terms of protecting the ozone layer by regulating the ozone depleting substances as well. So as I said, I mean, I could go on and mention, but the most important thing for us to understand today is that international law, as I said, is quite wide. It has quite a number of regulatory bodies and treaties and agreements, and the argument is to create an equitable, sustainable, perfect environment, perfect in quotes, but looking out for one another in terms of living in this bigger world, so that whatever we do it being mindful of our brother. We create that kind of relationship that we look out for the interest of our brothers and sisters to that effect. There is also the Convention on Migrant Workers, for example, 1990. That treaty basically protects the rights of migrant workers and their families in terms of covering issues such as labor rights, social security, and humane treatment. Yeah, and there's another interesting one which is extremely important, by the way, the International Convention on Economic, Social, and Cultural Rights. Super important one, the ICESCR of 1966, which promotes economic, social, and cultural rights, including the right to education, to health, and even to work. That one is super important. Don't forget also the Hague Convention on the protection of children and cooperation in respect to intercountry adoption. Yeah, the treaty basically establishes standards for international adoptions to ensure the best interest of the child, again, in terms of ensuring that our children are taken care of, or they are given the due respect as accorded by the law. Yeah, that's super important. You may want to also look at the International Convention for the Regulation of Whaling. That is 1946. The treaty basically governs for the conservation and management of whale species, and it's established the International Whaling Commission, what they call IWC, to regulate whaling activities. Yeah, so please, again, that's another that is important. Then you may also want to look at the United Nations Convention to combat desertification, the UNCCD of 1994. The treaty addresses land degradation and desertification and promotes sustainable land management and practices to combat these issues. Interesting to know that almost everything that probably you may want to challenge in terms of your right has actually been covered by way of the law. But the question is their viability in terms of the practicalness of them. Yeah, you may also want to look at the optional protocol on the Convention of the Rights of the Child on the involvement of children in armed conflict, which the protocol strengthens the protection of children in situations in terms of armed conflicts, including raising the minimum age for recruitment into armed forces, for example. Yeah, and so these are. So I could go on and mention substantively. I may not end when I'm talking about all these different regulations, but listen, the point I think has been driven home in terms of understanding that international law has really a big mandate and is very important in terms of day-to-day applicability. And we cannot ignore international law in terms of the things. Now, as I say, we will cite out particular cases in terms of particular fails that this law may have not played very well. Yeah. If I forget, there's also the Convention on International Trade in Endangered Species of the World Fauna and Flora, what they call the CITES of 1973. The CITES basically aims to protect international trade in terms of wild animals and plants that do not threaten their survival. It protects the endangered species, for example. Yeah, and please remember that. So, as I say, almost every angle has actually been talked about by our guardians who have probably gone a little bit ahead of us. But then the point is the viability of it. That to me, it should be the question that burns in your heart in terms of the applicability. And for me to argue the applicability or the viability of these laws in terms of how they have been enforced or how they are played out today, as of now, I may not end this discussion. I'll probably want to argue that we'll capture that in our next YouTube dispensation in terms of international law, where we pick out certain stories. But even so, we will have argued some of them. Some of you may want to visit our YouTube channel and look at, for example, the debate between Ukraine and Russia, and then the debate between its causes and effect, and then Russia and Israel and Palestine, the causes and effect. I have made a YouTube dispensation in terms of that, and made arguments in terms of where it started and where it is, and substantive challenges that come with it. Yeah. So I'll try to address some of those, or perhaps in another YouTube, in terms of playing out some of these particular challenges that particular countries. I've been fair enough to mention some countries as well. But again, go to our website, lubogo.org or suigenerislawup.com, but also look out for some of the books that we've written. We have written probably about 50 now running, and all of them are readily available at Amazon, at Smashwords, Digital to Draft, at Lambert, and many of these leading bookstores in the country, but also majorly on almost every repository on universities that we have in our country in Uganda. So my friends, welcome again, and thank you for your attention. My name is Isaac Christopher Lubogo, and go visit our website at lubogo.org and suigeneris.com. God bless you, and thank you for your attention. I will take leave for now. Thank you so much. God bless.